truly free thinking and acting American will not wait for the TV or newspapers in order to act on something that might be original and they have never seen it before. This is called the Poor Man's Bill of Rights, not privileges, oath of arrest and prosecution. As per the Holy Bible, Deuteronomy 19:18 through 19 of the Bible, which says, and the judges will carefully inquire, and anybody be a false accuser, they'll be severely punished. And Exodus 20:16 of the Bible, which says, you will not bear false witness against anybody, because telling a lie on somebody could cause the whole community to hate them, even though there is no evidence whatsoever. An example could be somebody could have all kinds of scars from self-defense, and yet they could have legitimately defended themselves. For all 50 states, for police, public defender, etc. A non-negotiable binding contract of understanding between citizen and police officer. That means there is no wiggle room whatsoever. 1. I, a police officer, especially cops, public servant, under Miranda versus Arizona, 1966, which is where somebody was forced into a confession, but a lot of times the poor person is forced into a confession because they end up, if they want to maintain their innocence and they can't afford bail, they could be many months in jail. Now, Brady versus Maryland is a landmark case of where it says the prosecutor shall not hold back any evidence that could clear the accused. Example is Ryan Ferguson spent almost 20 years in prison on a false charge. So did Brian Banks. He spent 5 years in prison because there was this bitch whore cunt, greedy bitch whore cunt, who decided she wanted to make money off the school and claimed that she'd been raped. And by using a secret tape recording, Brian Banks exposed her, but not limited to the above. 2. The cop swears under immediate imprisonment, no bail. 3. No letters, 4. No visitors, 5. No commissary, 6. No special privileges, 7. No protective custody, 8, which is a common tactic that could be used to hide the cop, making people think that he's in jail, but he's actually told go to another part of the United States and don't come back no more. So nobody has proof of them being there. 9, to do the maximum time, day for day, 10, stacked end on end, the following or more felonies. 11, United States Code, Title 18, 241, 242, which is a $10,000 fine and 10 years in prison. 12, which is, I have found in every cop's manual, every cop is warned about this. So there is no need for any court decision. It's final. 13, racketeering. Racketeering is when a cop protects a criminal conduct or action, either through actions or inactions. 14, 895 of the Florida statutes. 15, to violate the public servant oath, which means anytime somebody goes into office, they swear an oath, a solemn promise to protect citizens' rights and to put their evil intentions behind them. And when they don't do this, 16, then they have committed perjury. Perjury is when any public officer goes back on their word. And it does not have to be something at an official court proceeding, which they lied to you about. 17. Bribery or to procure an evil benefit. That could be something to where a cop is accepting could be money or anything like that, to look the other way on corruption that's going on. An evil benefit could be where the cop decides he wants to intentionally torment somebody because he doesn't like them. He doesn't like them standing up for something that a lot of people are afraid to do. 18. 838 Florida statutes. That's called conspiracy, which has to do with violating the public servant oath. And also, that's under conspiracy, which is when two or more people decide that they want to agree on through actions or inactions to do something that violates the United States citizens' rights. That the person being arrested has been given a number-controlled form 20 to write down their side 21. 22. While their incident witnesses, character witnesses, alibi witnesses, and other evidence is still fresh 23 in their mind. And that I, the cop, 24, are compelled to preserve 25. 26. Any favorable witnesses. 27. Evidence. 28. Unknown at the time of the controversy or arrest or incident in question that could clear 29. The accused. And what that means is when the cop could and part of a personal story only the accused could know, accompanied by the accused's fingerprints, to keep them from being lost in the jail system. 30. Forwarded to any official court or official procedure under immediate prison for failing for the cop to do so. Now, what that does is that makes it to where a cop knows that if he does not include the accused side, which could have prevented the arrest in the first time, then that means the cop's going to go to prison immediately, no bail. 32. Get the fingerprints are part of a story that only the friends or family could know of the accused. 33. Unlimited questioning rights of the accused to anybody, including but not limited to the judge, the prosecuting attorney, the cop, the accused victim, the victim's claimed witnesses. 34. I further swear this person 5 was unprovoked in starting the original trouble or incident, and was not even faintly 37 a reasonable, personable, unalienable rights defense. Examples like this. In Panama City, Florida, there was somebody who was accused of tearing up a Burger King. And yes, it was on video. You can go to YouTube and you can see it. But the truth of the matter is maybe she was insisting on getting a quality product and they spit in her food. So what happened was is she went absolutely crazy. And I think the average person, if they saw a great big hawker in their food, I think they would too. But now, if they were more interested in putting charges on than getting to the truth, this is a common tactic that is used. 38. The accused crime originated in the mind. 39. And could have been avoided. Examples like this. Somebody who snatches somebody's purse has it in their mind. The victim has no idea that it's going to happen, has no idea that it could be avoided, but if the original thinker of the crime decides not to do it, then the crime is avoided completely. And it was not a constitutionally constitutionally protected act of peaceful assembly or attempting to stand up for a God-given unalienable right. A God-given unalienable right is your right to be able to sleep, have nobody disturb you whatsoever when you're sleeping, your right to be able to live in peace, not to have somebody disturbing you down the street, your right to be able to eat as much food as you want, if you lawfully bought it. This person was not contesting a questionable wrongful practice of hate, such as trespassing, where no fence was violated or crossed, and was open to the general public. This is a common tactic that is used, that if a business does not want somebody to find out the truth about maybe they're selling rotten meat or something like that at a grocery store, maybe there's bugs in the food, or maybe the people that wanted to find out the truth about what was going on with GM with the defective 57-cent switch, it is a common tactic to use trespassing or disorderly conduct to bar them from being able to get in to find out the truth. Another example is Jill Stein. When she wanted to get into the presidential debates, who was a doctor, who had probably been a more highly qualified president, she was arrested to keep her from going to the debates. 47, this person was not unprovoked for no good reason causing the disturbance. So therefore, if a person has a legitimate reason, the cop can't turn around and say they did it for no reason. 48, the cop swears. 49, he did not use any entrapment techniques, which is 777-201 of the Florida statutes, did not use any tricks, escalation, confusion, intimidation tactics in order to anger the person, in order to up the charges. Common tactics are a cop interrupting somebody, a cop using secret, highly painful pressure points that the average person in a crowd might not see being used to cause the person to possibly resist and then get battery charges on them. 51. And the incident that it does happen, 52. I no longer get official, state, federal, local government protection, as it is a common tactic for cops to use enraging techniques such as assault bait to up the charges. Example, as I said, was about secret, highly painful pressure points, using techniques to enrage somebody instead of trying to de-escalate the situation. 54, I further swear I carefully did an investigation by a checklist of the controversy and did not let my personal prejudice, if any, enter into the investigation. That means if a cop does not like somebody, or they happen to have personal connections to where their emotions would affect their judgment, then they are to hand it over to somebody else. That they gave an investigation checklist, which is under 57, to the accused so they could double check my performances. Now the reason for that is maybe the accused could never be arrested in the first place, because through the checklist they could find out that the cop was trying to frame them. 58, the arresting officer's signature and fingerprints mandatory, or mandatory option for the arrested and the accused, that they can say, I do not want the following information filed in by the officer. And the date is given and the signature of the cop, And if the arresting officer has nothing to hide and is not fabricating evidence, then they will freely and voluntarily sign and fingerprint below. Notice that the fingerprints would be put down: the thumb, the index, the middle, the ring, and the little finger of the cop. But it would be of both hands, because maybe poor Anna Beach might not have been murdered by a cop in Panama City, Florida. Mark Bamia, who is now in the Florida Department of Corrections for the rest of his life, who was a cop who murdered her, not only that, shot her and strangled her. 59. All juries to be tested for intelligence and fairness, or to be considered ineligible to serve. And I contend that it should be done under perjury. 60. No arrest or jailing without photos of any provoked hateful damages. Now what that would do is that means a cop couldn't just put charges of claims on somebody. He would further have to back it up with photo proof. 61. Common cop hate tools are disturbing the peace, claiming it when a person is only trying to stand up for their rights, especially if you're questioning a cop, trespassing where no fence was crossed or violated. And the reason for that is trespassing is a common tactic that is used to protect a corrupt business. This ends American bad cop terrorism forever. P.O. Box 952, Panama City,